Good morning, everybody. Welcome to July's Employment Coffee Briefing. As we said during the end of last month's session and the marketing content that's gone out for today, we're going to step away from the employee life cycle for today's session and focus on some of the things that the main parties are saying about potential change to employment law or ideas that they may have as part of their manifestos for the election. I'm sure everybody's noticed the election is tomorrow, so I thought I'd do this special for this month. I promise no podiums apart from the one I'm stood in front of that fortunately you can't see, no debates, but I am happy to take questions from my live audience, of course, and I will do my best to answer them honestly and completely clearly. As always, the session is going to be recorded. It will be available afterwards. Please do feel free, as some of you already did over the technical issue at the start, to make use of the Q&A function if you've got anything you want to say. I will do my best to answer questions, but obviously today's session is going to be a little bit more speculative. We don't actually know what anybody is going to do. We don't actually know what the consistency of Parliament is going to be in a few days' time. The last poll I saw that came out yesterday evening strongly suggested Labour with well over 400 seats, and the so-called supermajority is looking quite likely, but I'm not going to make myself look foolish by saying that's definitely going to be the outcome, because who knows. And that same poll does strongly suggest that there'll be a bit of a toss-up at the moment between the Conservatives and Liberal Democrats for second place. So I am going to focus on those three parties because they are the parties that, like it or not, are most likely to be influencing Westminster politics for a given value of influencing over the course of the next Parliament. So I won't touch on what the regional parties have said, partly because the scope of employment rights is not a devolved issue in that way for Scotland, Wales and Northern Ireland, to the extent that other issues might be. And of course, I can't really comment on the law in Scotland or Northern Ireland anyway. I'm qualified England and Wales. So yeah, today's session a little bit speculative because, of course, partly we don't know who's going to be in power, partly we don't know what they're going to do if they do and what opportunities they will have if they do. A lot of what has been said has been hinted that it will come in very quickly. There's been a lot of talk around what some of the policies and manifesto points are actually suggesting. So I think let's see what comes out of this. Those of you who were at our session in person yesterday will have had a brief introduction to this already. I am going to focus slightly more for this session on what some of those policies might look like, how they might actually materialise. So without further ado, let's start with what the Conservatives have suggested. As we know, the Conservatives have been in power for the last 14 years, and so I think we can safely expect more of the same from them moving forwards. Major employment law changes, major HR issues have not been a priority over the course of the last 14 years necessarily. It's true of the manifesto again moving forwards. Their manifesto has very little in the way of employment issues, but obviously let's bear in mind we have seen a wave probably in the last couple of years of changes to equality legislation, statutory leave entitlements, and of course things also like tipping allocation and the way flexible working works. More of those might follow in due course if we do still have a Conservative government at the end of the week. Most of the changes that they've made recently, those ones I've just referred to, have been, I think, relatively uncontroversial. I don't think they've caused any drastic change or drastic issues for people that I've noticed yet. Or where they've been implemented, they've been designed to try and enshrine either existing EU case law to allow continuity, or to assert the preferred British version, such as holiday calculations. Where we might see changes, and I'm not going to go through everything that has changed in the last 6 to 12 months, but some of those equality changes, the duty to prevent sexual harassment coming into force, for example, the changes to flexible and consistent working patterns are all things that are going to make a difference moving forwards, of course. But as I say, what it means is there's nothing too outlandish in the manifesto itself. And what we've really seen is these 4 points. They're the only 4 I could find that really related specifically to employment issues. So changes to the fit note system. The idea simply being here, we've seen already a discussion about getting people who are on sick back to work, and I think that policy will continue. But at the same time, the proposal that is coming forwards around the fit note system is to extend the nature and kind of professionals who are able to sign them, quite simply. And that is about reducing the burden on an individual's GP to be providing them all the time. And the second big issue, I suppose, is the idea of these minimum service level agreements. These were introduced as a reaction to the public sector strikes, particularly public transport and the NHS, that we've been seeing over the last couple of years. And ultimately, the intention is to say that even where strike action does take place, there is an obligation to ensure that a minimum level of service is always provided. I'm not going to try and convey too much a political opinion or to suggest that whether any of these issues that are being discussed over the next half hour or so are politically motivated. Let's not forget there has been an ongoing dispute for a long time about this. There is an argument, of course, that providing a minimum level of service somewhat defeats the point of having a strike in the first place. But it is a policy that is there, it is a policy that exists. For the time being, it seems to be focused on the public sector, but we are all in sectors where strike action can and has taken place in the past. It may well be that it extends into other areas in due course. The other two big issues to come out of the Tory manifesto, just in case anybody's noticed, Rishi Sunak's been a little bit obsessed with tax lately. He is continuing to make these points in the manifesto with cuts in national insurance for everybody towards the end of the Parliament, or certainly the mid of the Parliament, for the employed individuals, and the complete abolition of national insurance for self-employed by the end of this Parliament. Again, I've no doubt there are people on this call who will celebrate that. Those of you who are self-employed, it is simply a tax reduction for you. Of course it is. From our point of view, though, as employers, as HR professionals, this doesn't actually drastically change what we're doing on a day-to-day basis. I've just had a question about employers' national insurance. They've not been entirely clear on this. The suggestion seems to be that there is a reduction. There'll also be a proportional reduction in both. It's a little bit vague on this point, and I think we'll come back to what everybody has been asking all the parties in the debates. If you keep cutting national insurance, if you keep cutting taxes, where's the money coming from? It's in there. Whether it happens or not, whether it's feasible for this to happen by 2027 is a different question. No doubt in 2 or 3 years' time, we will have some more guidance as to exactly what that looks like and what those payments will be. I suppose the point from the Conservative manifesto, though, really, is the last two of those are obviously more tax than employment law issue questions. I can't advise on tax. I can advise on them in an employment perspective, but I'm not qualified to give tax advice in detail to an individual or a business. And the other two are very much continuation of existing policies. You know, the addressing strikes is something they've been doing already, and changes to the fit note and sick pay and sick leave regime is all stuff that has been discussed quite publicly over the last few years anyway. So I think from my point of view, and as I was hinting out there with the tax points, there's nothing kind of brewing at the moment that suggests there'll be major changes for employers or HR practice beyond the things that we've already been talking about for the last 18 months anyway. So those changes to holiday when they come in, those changes to the Equality Act when they come in, changes to tip allocation, those kind of things are the ones we're going to see. And I think for a lot of people, some of those are going to be quite big and drastic changes anyway. So I don't think there's a huge amount coming out of what the Conservatives have said that is particularly exciting. But if anybody else has seen anything or wants to comment on anything before I move on, obviously please do be my guest. If not, I'll start to move towards people who the polls are currently suggesting might do a little bit better. No, wasn't expecting anything, so I'll take that as a good sign. Right, let's talk about the Liberal Democrats. So, as I said at the start, I'm including the Liberal Democrats here because, again, looking at the last poll that I saw last night, there's a non-zero chance that the Liberal Democrats could, in fact, become the official opposition. Again, I don't know how much we trust the polls, I don't know how much we rely on them in order to plan for what an election outcome might look like, but this was showing a somewhere between 5 and 10 seat potentially difference between the Conservatives and the Liberal Democrats. And if the poll is correct and the various possible swing seats shift the way they do, we may well see a Labour government with a Liberal Democrat official opposition. If that's the case, then as the official opposition, a certain amount of parliamentary time is given to them to raise issues, to table legislation. And so some of these could be put forwards with the view that if you have a Labour government with a Liberal Democrat opposition, some compromise position of these may be reached. So it is worth knowing what they're proposing, even if some of them are perhaps a little bit out there, a little bit more extreme than what the other two parties are putting forwards. The advantage of the Liberal Democrats, of course, is they have always been able to say things that hypothetically they would like to do. And similarly, in this election, they're unlikely to be the leading party. So it's very much a case of putting forward ideal policy, I think, rather than practical measures for the most part. That said, some of these do overlap with what Labour are proposing. So, as I say, there's quite a lot. Some are quite interesting, some are a little bit more out there, some are a little bit more controversial, I suppose. So, the first one there, a new kind of status that they are calling dependent worker. And weirdly, the description of dependent worker that they've put in their manifesto appears to be what any one of us would call a worker. I think the actual intention is to try and fill the gap for contractors and the self-employed who are heavily dependent on a single business or employer. So actually for me, where that would sit, would be people more like consultant solicitors who work in a law firm, but as a self-employed individual. The only source of their work is through that firm. And there you can kind of see where they are a dependent individual who are maybe more akin to a worker. Detail is really vague on this, as it is, I have to admit, for most of the Liberal Democrat manifesto, and when we get there, the Labour one. But my reading is that it's got to be those kind of workers, because if this is about addressing the potential abuse of sham self-employed relationships, there's better ways of doing that. You actually tackle the sham self-employed status rather than try to create a new kind of status just to confuse everybody. Point 2 there is about flipping the current burden of proof in those kind of status claims. So where an individual brings a claim at the moment where they're trying to enforce employment or worker status rights, if it's not clear or if on paper they are self-employed, the onus is on the individual to prove that they are an employee or a worker. It's a standard across all areas of litigation in this country that the person bringing the claim has to prove their claim in the first instance. What's being suggested here is that the employer is going to have to demonstrate that the relationship is a genuine self-employed one if that claim is brought. And I think that goes to echo what I was just saying about point 1. This seems the better way to address sham self-employment relationships than to try and produce a dependent contractor status to try and catch those people. It would possibly tidy up, looking back, some of those cases where status was the big issue. So the Uber cases, the Pimlico Plumbers one, again, they kind of echo that idea that it's possible to be self-employed within an organisation in theory, but to be so dependent on that organisation that you are functionally, and in most of those cases legally, a worker. Point 3 talks about minimum wage. Proposal to increase the current statutory minimum wage by 20% for people who are on a 0 hours contract, with the intention being to compensate them for the irregular working patterns and the fact that they don't necessarily work as many hours as people on guaranteed or other forms of working contracts. So, as I say, yeah, obviously no guaranteed hours, and sometimes, of course, for people on 0 hours contracts, there is the potential for them to be working additional time for which they simply don't get paid. It just becomes an element of necessity within their role. I think if there's going to be a problem or any criticism with this, it will be an argument that we are starting to reward people financially in some situations where they have chosen to take on this contract for the benefit of the flexibility. And I can see a dispute arising there before this is passed around to what extent should we be saying that 0 hours contracts are a benefit for some people in terms of flexibility, where they can then in theory also be benefiting financially compared to other people who are on minimum wage. Obviously, I take on board that there is scope, significantly more scope for abuse of workers on 0 hours contracts, but I know many people on this call will use them in their business, and I know many people on this call will be using them quite well and successfully, and therefore maybe somewhat critical of a 20% increase for people who seem to be on a fairish deal anyway. Point 4, statutory sick pay, making this a day one right. Yeah, it's currently got that required length of service. They're also talking about removing the earnings limits. The earnings limit for most statutory payments is the threshold at which an individual starts paying national insurance on their weekly pay. So to scrap that completely, and as we said, they make SSP a day one right. I'm not sure there's anything too controversial about that. It would potentially require a change to your procedures and the information that you were to give a member of staff, but because it's a statutory entitlement, it would obviously supersede anything that is said in a contract or policy anyway. It would just be a case of making sure that people were aware this kicked in. Financially, of course, as with most statutory payments, there's scope for employers to be recovering statutory pay, statutory maternity pay, statutory sick, whatever the case may be. So I'm not sure that that is one that would make a huge difference to the majority of people, other than from an administration perspective, and it being a little bit of a nuisance for payroll. Again, double statutory maternity, statutory paternity, and presumably, although it wasn't entirely clear, adoption pay as well, to £350 a week. Again, much as I was just saying, a statutory sick, not sure that would make a huge difference to people procedurally. Again, these are recoverable at either more than that or slightly less than that, depending on the size of business. Statutory maternity and statutory paternity, for those of you who've been on it, you'll probably know it's quite low anyway. It's not an easy amount to live on for the entire period that you might want to take off. So there is some obvious benefit to people in increasing this figure. Again, at the risk of turning into politics, however, that does simply increase the social security budgets to some extent. Adjustment passports is a potentially interesting one, and it is one of those ones that might make its way out if disability access to work and return to work are going to be discussed more by a new parliament in due course. The suggestion seems to be a travelling document which an employee could take with them between employers. And in effect, it would be a case of, well, here's my disability, here's the adjustments my previous employer attempted or put in place for me, and here's the impact they had, here's the benefit they gave, here's where they helped, here's where they didn't. And to an extent, you can obviously see a benefit in that. It replaces almost the need for that awkward conversation at the start, which can sometimes take place. It may reduce the need for occupational health assessments if the role is substantively similar. I think my issue with this is it potentially defeats how we perceive disability in the workplace and how reasonable adjustments actually work in practice. To me, reasonable adjustments are designed to suit a particular disadvantage suffered by a particular member of staff with a particular disability in a particular environment. It has always been a defence in reasonable adjustments to take the argument that just because it worked previously doesn't mean it could work here, doesn't mean we could implement it here. We're a different employer, it's a different setup. So in certain areas, yes, it might work. Shifting between an office environment to an office environment that is substantively similar, yes, this may save time, this may save procedural tick boxing. But I think where there's a significant change in the working environment between one job and another, I'm not entirely sure how helpful this is going to be, or whether it would assist an employer in sort of bypassing their obligations to consider reasonable adjustments anyway. Parental leave and pay as day one rights, yeah, they're things that we had discussed on the previous session. There's not a huge amount to say about those. This may simply require a review of policy and procedure in due course. If it did become possible to start taking these forms of leave earlier, I don't think there's anything too exciting about those. Again, it would be a statutory change, it would supersede anything in a policy, and how that would look is something that's not remotely clear from the manifesto. Last one on this page then, introduce a new Equality Act protected characteristic around being a carer. I feel like a broken record here, but this one is again exceptionally vague. There's no proposed definition of what it means to be caring or a carer or for whom. I think most of us could probably say, if we just took care to take its normal day-to-day definition, well, most of us will be able to argue that we're caring for a partner, a child, a disabled family member, an elderly relative, a pet. So we don't actually know what that's going to look like yet. If I were taking this approach, I would probably say that this would look more like an extension of the ability for an individual to claim discrimination due to the association of being connected with a disabled individual, for example. Those claims are theoretically possible. They're not particularly easy to run, but I think that would potentially be a better way to explore this than to try and introduce an entirely new protected characteristic, unless the intention is to draw it in and use the same set of criteria that carers leave has just been allowed for. That said, if you've then got a carers leave entitlement, there's an implication that there's a discrimination claim there anyway, and this could just end up complicating which protected characteristic you were claiming under. It will be interesting if that does get discussed to see exactly what the definition of a carer is considered to be. We know that disability is very different for equality legislation compared to what the DWP call it. I suspect this would be very similar as well. Any thoughts, comments, questions on anything, or is everybody literally just waiting for me to tell you what Labour's talking about and my views on it? Yeah, the silence tells me what I suspected. So let's talk about Labour. So I strongly suspect this is the one that everybody is actually trying to get some information about and trying to get an idea of what it might look like. So I'm not going to set myself up to look incredibly foolish on Friday morning by saying we will have a huge Labour majority, but I think we all know it's looking likely, and no doubt most of us have already heard about some of the proposals that Labour is putting forward in its manifesto. Obviously, some of these were leaked relatively early, some of these were announced relatively early. There has been some talk about the watering down of some of these proposals compared to what we'd initially heard about them a few months previously. But I do think what is there remains a relatively significant set of manifesto points. What Labour have suggested is that they would table some kind of draft legislation within their first 100 days of government. If they get in at the end of this week, that means that we could be looking at draft legislation around October, November, certainly this side of Christmas. That said, they have also talked about wanting to consult, wanting to be the party of both workers and business. So I think this will be very, very draft legislation. And there are significant sections of this that I can't see coming in particularly quickly, because I don't think it's going to be practical for them to do it. And I think they've got other bigger immediate priorities. I'm sure most of us would agree. That said, we've got Labour's snappily titled Plan to Make Work Pay, delivering a new deal for working people. As I say, for the most part, I think it does echo things that have already been announced. So what I'm going to do, running through some of their things, is I'll draw out some of the headline points. Again, as I've been doing some of what I think it might look like, how it might work, and just my general views on it. Again, if people want to keep chipping in as we go through these, by all means, be my guest. I'll try and make sense of any questions. But the answer is likely to be, we just don't know at the moment to some of this. So, in terms of contract and working patterns, first thing they said, ban the use of exploitative 0 hours contracts. So everything I said about 0 hours contracts in relation to the Liberal Democrats still has some relevance here. We know that it is easy to take advantage of people who are on 0 hours relationships with an employer. Not that I'm suggesting anyone on this call does that, but it can happen, it does happen, and it's very easy to do. We've already seen under the current government a ban on exclusivity clauses in 0 hours contracts to try and control that. I think what's interesting is where this is one of the watering down ones. There had been talk about banning 0 hours completely, and I think what's probably been realised is, as we were saying earlier, there are people who are on 0 hours contracts because they choose to be, because it benefits them, because the flexibility works for them. Very unclear as to what Labour's definition of exploitative actually is here, but I think, so that I can move on as I go, it probably ties into point 2 here, and I think it will relate to hours worked and almost that limbo state that a 0 hours worker can find themselves in. So what I think is being suggested by point 2 here, too much regulation around this undermines the point of 0 hours contracts. Some people, as we were just saying, choose to be on them for flexibility purposes. And I think what this is probably suggesting is that there will be a degree of guaranteed time, but in a much longer reference period than currently. So people who are employed as workers at the moment on flexible hours may have a clause that says something like you work a 30-hour week at some point between 8 AM on Monday and 6 PM on Saturday. Hours will be communicated to you on a bi-weekly rota system, for example. I think what the implication here is yes, it's a 0 hours contract. We're not guaranteeing you any particular time or hours in any given day or week, but over the course of, say, a 3-month period, we will give you 40 hours in that time. And that may balance out some of the exploitation limbo that is still inherent in these contracts. That's only, as I say, my speculation on it. It combines those 2 points, but it seems a sensible way to combine those 2 areas based on what they want to do. Again, just to be clear, I'm not suggesting it's a good policy or that it's necessarily a positive one, just that seems to be the sensible approach if that is the intention. Third bullet point there, end the use of fire and rehire practices. So having used the word ban in relation to exploitative 0 hours contracts, Labour actually falls short of using the word ban in relation to fire and rehire. I suspect what we're going to see in relation to fire and rehire is use of carrot rather than stick. And it's going to be actively discouraged. They will probably find a way to make it a little bit more difficult. We'll come on to that shortly as well in what I know is the big headline everyone's waiting for. But I think the problem with completely banning fire and rehire is that while it's not great, while it has a certain amount of stigma attached to it anyway, think P&O, there are situations where it is a tool that an employer may need to use. You may need to impose certain contractual changes, and the only way to try and do that is to terminate the existing contract and bring in new ones. It may be that the only way to effect a complete restructure, if no other method can be agreed, is the use of fire and rehire. We haven't got an alternative method because in other parts of the world, I mean, the US in effect don't have the employment rights around unfair dismissal for the most part that we have. And in Europe, that kind of process is all done through collective bargaining and negotiation. We're sort of an outlier here in that we need a system to be able to effect those changes. So a complete ban functionally wouldn't work, but saying it ends the use of strongly suggests that there is going to be a push towards discouraging employers from doing it. It will probably be tightening up the new ACAS code as and when that comes in full force. And it may well be that there is some kind of additional sanction where fire and rehire is used badly. Last one there on this slide talks about a presumption of flexible working. That's how I've chosen to word it. The full details are a little bit unclear, but the strong suggestion is that it is an extension of what is currently simply a right to request. We all know that the right to request is there and that it's just changed, and that the way flexible working requests are done is changing moving forwards. I think this is potentially going to go a step further than that if it is implemented as policy. So even a slight tightening on the current regime would almost produce, I think, a proactive duty on an employer to accommodate a request so far as reasonably possible. It would put the duty back on businesses to justify why it couldn't offer the flexible working that is being offered. And I think the only way to do that easily under the current legislation would be a review to that list of reasons that we can reject a flexible working request. Those of you who have dealt with flexi requests will know that the majority of those reasons ultimately come down to we don't want to, some vague reason about it affecting performance, it affecting impact on clients, customers, colleagues, etc. Just changing that very, very slightly, removing a couple of those, would, as I say, almost create this presumption that flexible working is going to be allowed unless it cannot reasonably be offered at all. Think, to all intents and purposes from a language point of view, I suppose, think reasonable adjustment. The obligation potentially would be to allow flexible working where it was reasonable to do so in order to accommodate the employee's needs. Again, just to be clear, purely speculation, please don't cast your vote based on me guessing how these things would look. Statutory rights and discrimination, including the big one, I will get on to unfair dismissal. So, day one rights for statutory sick, various forms of parental leave and other entitlements. Touched on those when I was talking about the Liberal Democrats. They are in effect the same policy. I don't see it causing, as I said earlier, a huge impact on anybody other than from a procedural administrative point of view. Small businesses, of course, meaning people have more immediate day one rights, is always problematic. But for the most part, I can't see them requiring a massive change to the current system. So, day one unfair dismissal rights. That's where everybody wakes up. As we know, the current rule is that an employer must generally show a fair reason to dismiss. Redundancy, conduct, capability, illegality, some other substantial reason, the ones set out in the Employment Rights Act. If an employer does not establish that one of those is applicable on the circumstances and dismisses an individual, that employee can claim they have been dismissed without cause and therefore unfairly dismissed. This does come with the big caveat that an employee can only bring a claim in those circumstances, forgetting for a moment all the various automatically unfair reasons, if they have 2 years continuous service with the business, dismissed. A day one right would potentially remove that limitation entirely. So what that means in practice, if it is done in as black and white a way as that, for redundancies, capability and conduct dismissals, all employees could then become subject to processes and procedures, and indeed potentially the ACAS Code of Good Practice in relation to those processes. That means there's no more dismissal on notice just because they've got 18 months service, for example, and no more condensed procedures or processes in relation to disciplinaries or performance. It would potentially, of course, also catch a constructive unfair dismissal, although I won't go into too much detail about that because that's obviously less procedure-based. But it does, of course, also suggest that grievance procedures would then also apply in the same way. Not following the grievance procedure could give rise to a constructive dismissal claim. In theory, particularly for conduct and capability dismissals, most people recommend doing some condensed version of a procedure either way. And while, of course, there is going to be a new expense, a new time commitment associated with running those procedures now, even for people under 2 years service, it shouldn't drastically change how things are done. Again, I'm not suggesting this is a good idea. I'm not suggesting it's a great idea. But in terms of that process and procedure, everything that is in place for people with more than 2 years will simply become extended to everybody else if it's implemented in this way. So it shouldn't drastically change how you're doing things, just the number of people it applies to. And I say just, I know it's a big just. The one possible get out to some of this is that Labour have suggested that this 2-year limitation would still be subject to probationary periods. And for a very long time, probationary periods have been quite useful, but only in the sense that if you have a generous notice period, you can dismiss on shorter notice while someone is in probation. To all intents and purposes, that's only really been the benefit because they didn't have an unfair dismissal claim anyway. This, of course, changes that. Detail is vague, as I said it would be, and still subject to the consultation that Labour have said they will do with businesses and representatives of workers. But I think one option here potentially would be to make a failure to pass a probationary period a new valid reason for dismissal. And what that would have to come alongside is statutory or regulatory guidance on what a probationary period should look like. The other option, I suppose, possibly would be a limitation on awards where there was a clear failure to meet probationary targets. And I can't really think of another way to implement that easily without completely changing the concept of unfair dismissal. I can see the logic behind this. There are absolutely situations that I've encountered where I think to a layperson, the situation the person I'm talking to is grossly unfair. You know, a trumped up disciplinary being used as an excuse to dismiss for gross misconduct, which then sits on that individual's reference. If they're in a regulatory profession such as teaching or finance, it travels with them. And it was completely unnecessary because they don't have an unfair dismissal right, but they've also got no way to challenge it. And in those situations, I can see the value in this sort of approach. Of course, on the complete flip side, I'm talking mostly to businesses at the moment, people who deal with businesses. This could become administratively very, very burdensome very quickly. I think watch this space. I don't think it is something that is going to be implemented in August, September. I think there's going to be a lot of consultation on how this would work. And I have no doubt that the tribunal system will have a lot to say about the potential increased number of claims it would have to deal with in this situation. So I can't see an immediate change, but I think it is one to be wary of because it has been the headline policy for employment rights, and I'm conscious that everybody is aware of this. Just to throw one more spanner into the works for this, we'll jump ahead quickly to the very last bullet points on this slide. It's only a consultation, it's not a promise to do it, but the idea of a single worker status. Because as we know, we've kind of got this three-tier concept at the moment of employee, worker, and the genuinely self-employed. One thing that both the Liberal Democrats and Labour have suggested is we potentially need a single worker status. It'd be great from an administrative point of view. It'd make everybody's life much easier in terms of legal claims and status and understanding that there is only self-employed or not. But if there were a single worker status, all employee rights would be extended to those individuals as well. So where workers currently don't have certain statutory entitlements, redundancy, unfair dismissal, all of that could extend to them as well. And that really could then complicate things if we've also got day one rights on top of that. So these could be some pretty drastic changes to what it means to employ an individual if they are all passed in the way they appear to be presenting. Of course, as I say, very, very speculative at the moment. I don't think some of these are likely to pass in the way they've been presented, but the potential is there. The other couple of things that I just want to highlight on this slide then, a single enforcement body of workers' rights. Yeah, I suppose from that point of view, what they're suggesting at the moment is you've got the tribunal doing legal claims, you've got HMRC doing pay issues, you've got the ICO maybe doing data protection stuff. There seems to be an implication that they want a single body that could sit there and walk in, deal with health and safety, etc. I've just had a request to recap day one dismissal. I'll do it right at the end, that's not a problem. Extension of the tribunal limitation period, that's just 2 to 3 months. It should say from 3 months, it's currently 3 months. That would obviously give people longer to bring a potential tribunal claim after the thing they're complaining about. So not an issue. I don't know how much difference that will make. If people are going to bring a claim, they'll generally bring them quite quickly anyway. The ones that I've dealt with that have been out of time have either been just out of time because of a mistake, we're talking 1 or 2 days, in which case admittedly this one would help them, or they're drastically out of time and somebody's trying to talk about something that happened a year ago. So whether an extension to 6 months, again, just to be clear there, would make much difference, I don't know. Let's not forget that to all intents and purposes, by the time you count the ACAS period now and how that extension works, it's not far off 6 months in practice anyway. Labour have also talked about a right to switch off. This is something I've discussed in previous sessions, both in person and on webinar type calls. Yes, it is that idea that there shouldn't be a point of contact too often outside of working hours where it's unnecessary. There shouldn't be an expectation of people to respond to phone calls, respond to emails outside of working hours or away from their office environment. There is an argument that this is particularly important if we are going to see more working from home. Those of us who've done it, those of us who've been there, will know that it is very, very easy when your laptop, phone, whatever, are just in the next room to go and have a quick look at 10 o'clock at night, 6 o'clock in the morning. From an employee well-being and stress point of view, that is terrible for you, and it's terrible for staff as well. The extent to which it is actually happening and the extent to which it's actually being compelled is a slightly different issue, I would suggest. I think in many cases it's something people potentially do because they feel they should rather than because they're being told they have to, and that's a potential area of conflict if this kind of right were to be introduced. As I say, I'll come back to unfair dismissal right at the end. Let people jump off when I've finished and I'll recap that when we get there. So just move on quickly. I just want to touch very, very briefly on some of the things that Labour have said about trade unions, and the policies and procedures that they are now suggesting do seem to be a shift towards encouraging unionisation and union engagement in workplaces. Those of you who have already got active union involvement in your sectors, particularly be aware of this. Those of you who don't, this could start to impact on you moving forwards. So first one to pick up there, fair pay agreement. This is in effect starting to look like, whether national or regionally, sectoral bargaining in the adult social care sector, particularly in relation to fair pay agreements. That's pretty much all they've said on it, but there is a strong implication. We know, those of us who work in the adult care sector, that there is always a discussion around what is fair pay for the hours worked, the stress of the work, the nature of the work. So a strong indication there that is going to be actively encouraged in some way. Don't know what that's going to look like at the moment. Third bullet point there completely abolishes what I was talking about with the Conservatives right at the start, and these minimum service levels in the event of strikes. Not unexpected, of course, from Labour, that, as I was saying earlier, the whole purpose of a strike is actually to have a negative impact on the service that the business is providing. So the idea of introducing a minimum level of service does somewhat emasculate a union in that situation. So their proposal is to scrap that. It could well be something that happens quite quickly, simply because the Act is relatively new. There hasn't been much around it at the moment, and a very quick abolition vote through the House of Commons would get rid of that quite quickly. The other two are probably the ones where people may start to have a few more concerns about the potential involvement of unions in their workplace. So I'll go with the last one first. Introducing a right for trade unions to access the workplace for the purposes of recruitment and organisation purposes. At the moment, that is severely limited. Of course, if you've got an official trade union rep internally, they have certain protections in relation to undertaking their trade union duties. This would obviously be a step beyond that, and particularly for the purposes of recruitment. The idea that a trade union could actively come in to do a talk, to present, to set up a stand, to mark it on your notice boards, things like that, is a step towards encouraging union engagement and indeed union membership. And again, for organising purposes, it overlaps slightly with the existing right of internal trade union reps to come in and talk to their members. This again could be a step beyond that. It's the trade union itself coming in to facilitate whatever action it wants to take, and potentially having some kind of right of access there. Not entirely clear whether that's physical or digital access or how it would look. Again, very vague policies, lots of consultation needed with the trade unions, with workplaces, with organisations like ACAS, the Employment Lawyers Association, probably on how that would actually look. But be aware that I think at a real basic level, how we can interpret that is active encouragement towards union engagement. The penultimate bullet point there, I'm not going to talk about how complex recognition of trade unions is under UK law at the moment. what you need to know for the purposes of this bullet point, if it's not something you're familiar with, is that there is a process by which members of a union in a workplace can ballot to try and force a recognition process. And once that ballot has been reached, they have two processes that then follow. They can, with the assistance of ACAS, try to get the employer to voluntarily recognise them and agree what that looks like. Or if that process fails, there is a legal court application process to compel recognition. The process for starting either of those procedures is a 40% eligible vote requirement. And what Labour are suggesting is to remove that. They haven't said what they would replace it with, but the implication seems to be that the start of that process to get recognition would become a lot easier. So on the basis that they haven't said what they would replace it with, it seems to be that recognition would almost be a default process if there was a suggestion that it was wanted within the membership. So I can't tell you exactly what that would look like, but I know in the last 2 years I've advised 3 or 4 clients on potential union recognition and union involvement. And I know one of the things that we would have discussed is actually the extent to which they were likely to get that 40% vote. If this legislation were passed in this way and that eligibility were removed, of course that would become a non-issue, and you're therefore much more likely to have to go down the recognition route. Again, not one that I think is going to happen quickly or easily necessarily, because there is a lot to deal with there. And it's been a very, very long time, I think, since most of us have had to deal with significant union membership or union engagements beyond possibly recognising them for pay discussions or where they've turned up for disciplinary hearing. But as I say, I think the overall message is a shift towards encouraging union membership and union engagement. So it may well be that as we start to see these things coming in, there is some benefit to businesses, the businesses you're in, the businesses you potentially work with, in, I suppose, voluntarily starting to engage more with staff on things that trade unions start to consider to be issues. There's an awful lot to potentially unpick from that. I don't want to go into too much detail on unions because we could be here all day. But does anybody have any thoughts, comments, anything on anything I've said about Labour? If not, yes, Vicky, I will recover day 1 unfair dismissal. Okay, just while we're waiting to see if anything comes in, I will just say very quickly then, if you don't want to re-listen to what I said on unfair dismissal, please feel free to start signing off. The next session, Wednesday the 7th of August, we'll go back to the employee life cycle. We'll start looking at considerations in redundancy situations. If the government does change at the end of this week, we will obviously keep people updated on things as and when they happen. We have a planned, I think, in-person event sometime in October at the moment, which you'll hear more about in due course, which will cover any legal updates that we can be more certain of at the time. If not, thank you everybody for coming. Enjoy the rest of your day, the rest of your month. I will see you in August. And for those of you who didn't catch it or wanted to review it, I'll go back over unfair dismissal very, very quickly. Right, so IT can stop there when they come to record this. Yeah, so just to go back over the unfair dismissal point very quickly, what I've said in very, very quick terms, we've obviously got the current situations where people can terminate employment fairly. So that is redundancy, conduct, capability, that it has become illegal to employ the individual, or that some other substantial reason catch-all. If an employer does not establish one of those reasons and the individual has more than 2 years service, the individual is able to bring a claim for unfair dismissal. The caveat being that that individual has to have had 2 years continuous service at the point when they are dismissed in order to bring that claim for one of those reasons. For redundancies, capability and conduct dismissals, therefore, the suggestion is that all employees would then need to be subject to all of the processes and all of the procedures in order to establish that that reason was legitimate and that the fair process had been followed. It's also likely to mean that they would be subject to ACAS code of practice on disciplinaries, grievances, etc., simply because it would also potentially catch a constructive unfair dismissal. And then in terms of disciplinaries, the ACAS standard is the minimum in that situation as well, of course. So what goes apparently under this proposal would be that kind of on notice dismissal at 18 months just because, or because of one of those reasons, but we don't want to go through a procedure. What I then said was that particularly for things like conduct and capability, a lot of employers, and I know a lot of HR reps and employment lawyers suggest that there is still a condensed version of a process because it generally helps the individual to feel less aggrieved if there is some demonstration of wrongdoing. And that while I think we have to accept that there is a expense and time commitment to doing that, it doesn't actually drastically change the concept of process or procedure. Where it was being done for staff who only had more than 2 years service, potentially, it's now being done for everybody in full, so that we can actually establish that misconduct or capability issue. All of this is also subject to the fact that Labour have hinted it would be subject to a probationary period. The detail on that is incredibly vague. It's still subject to whatever consultation Labour want to engage with whatever interested parties that may be. But if it were me, I would probably be adding the failure to pass a probationary period to that list of 5 fair reasons and simultaneously producing either some kind of ACAS code or regulatory guidelines as to what a probationary period looks like. Yeah, I mean, that is the answer. You potentially extend your probationary periods, which currently are somewhat meaningless because all they do is allow you to terminate on shorter notice, potentially. I don't think it would change the fact that you had conduct and capability as separate reasons to allow termination. They would probably, if it were me in addressing that specific issue, I would probably say that the capability, or sorry, the probationary period failure would only apply within a certain period. It may well be that they put a 2-year limitation on that, and that beyond that you can't then terminate for failure to pass the probationary period, for example. Again, this is where it's all very, very vague, vague planning at the moment, and it's not really clear what they are suggesting because it's not necessarily particularly well thought out. This is why they want to consult with sort of interested parties on it. And then, yeah, you probably joined Vicky just as I was mopping up there as well. The other thing, of course, to bear in mind is this consultation on a single worker status, which means that these unfair dismissal rights would also extend to anybody we now consider a worker if that were to pass. And then you probably joined just as I was mopping up and saying, these are going to take time. I don't think these are going to be things that are implemented particularly quickly. But to me, as I say, that seems the most obvious way to implement unfair dismissal subject to a probationary period. There's got to be some get out for engaging someone who simply can't do the job as well as they may be presented that they could. Anybody got anything else they want to add? Anything we've talked about today? Any questions, queries, etc.? If not, I will let you go and enjoy your days. No, in that case, thanks to everybody who stayed on, and no doubt we'll catch up soon.